I think we've made good progress. We've understood the structure, we've understood legal and economics. But I think a key question is, when will your case get funded? Because there's a lot of litigation in the market. There is enough volume in the market. And as Tom said somewhere, that he wins 90% of the cases he funds. So definitely he looks at something in the case before he puts his money. So what are these case considerations? And I think how do you prepare to go to marquee funders like those on this panel to fund the case? My two-bit, before I move into the panelists, is diligence, diligence, diligence. You need to spend time. You need to construct. You need to go on the drawing board. You need to be sure about your merits. You need to be sure about your jurisdiction. You need to be sure about your quantum, about your recovery, and about your prospects of settlement. And when I say sure, you should be able to put a percent as a lawyer when you draw your brief. You should be able to put a pen and say, I believe that there is a 75% chance this case is going to succeed. That's my experience on taking a case to the funder. But of course, let's ask the guys who have deep experience and who do this for a living. Tom, what are the factors that funders consider in evaluating and agreeing to fund a case? And can you comment on some of the most frequent reasons you throw the file out and reject the claim?
Sure. I'm sure that there are differing approaches from different organisations, but I would imagine that we all apply three main key metrics. And that is, first of all, the merits have to be there. Second of all, you need to satisfy yourselves you can recover. And thirdly, the economics need to work. And so to unpack those a little bit, on the merits, as you said, Pratik, some funders might look for 75% success. That's not our benchmark. We look for cases that are highly likely to succeed. We tend to look at numbers as being relatively arbitrary. When somebody presents me with a case that's 75% likely to succeed, I always ask, well, why not 76% or 74%? The truth is we're looking for cases that we believe, evaluating all of the merits, the legal basis, the potential defences, that they're going to succeed. And that's a very detailed process, and in particular in the infrastructure sector. The nature of those disputes make that a very complicated part of our due diligence. Recoverability, we need to make sure that the respondent's able to pay. Again, that's linked to the non-recourse nature of the financing. And we do much of that in-house. So we have a designated asset tracing and intelligence team that helps us ensure that parties are able to pay. And if they're not able to pay, that we're able to enforce. And we work up quite complex, often multi-jurisdictional enforcement strategies for the benefit of our investments. Lastly, the economics, the costs need to be proportional to the likely recoveries. And we tend to look for a 10-to-1 ratio. So if your case is worth $10 million, it's got to cost less than $1 million to get there. And the aim of that is to ensure that the bulk of the recoveries, once the lawyers have been paid, once we've received our funding fee, the bulk of the recoveries is still going to the clients. Aside from those sort of three key factors, there are also soft considerations. Disputes roll on for a long time, often 2, 3, 4, sometimes longer years. And you need to make sure that the lawyers you're working with, that you can work with them in a collaborative way over that time. That the client, the funded claimant, is going to be reasonable when it comes to issues like settlement, and that you will all get along when litigation eventually throws the eventual curveballs that it will. So those are important. And why do we decline cases? Often it's because the economics don't work, frankly. And I would say one of the other major reasons is probably more of a soft factor. If a case gets pitched to us on the basis that it's an absolute slam dunk, or that it's worth billions of dollars, when there are obvious issues with it, or there's obvious questions around quantum, then that's a real turn-off. when you're presenting a case to a funder, you should present it warts and all, and you should say, this is the case, these are the issues, this is why we think we have the better of the arguments. But the second you start glossing over the issues or not giving the full story, that will be a turn-off, at least for us.
Very, very interesting to note that, Tom. Sindhu, an essential component in deciding if and how much to fund, of course, is the fees, because you're in the end in the business of paying legal fees. How does a funder approach budgets? What happens when the initial assumptions or considerations change or radically change in the course of the matter?
Sure. I mean, as Tom said, when a funder is deciding whether or not to fund the case and how much to fund, frankly, separate from merits and enforcement, the funder is thinking about the economics of it. What's the ratio between the expected investment and the expected damages? And at the end of the day, can I, as a funder, earn a reasonable return on my investment? And B, can the claimant retain a good portion of the damages? Usually at least 50%. And most good funders will want to make sure that the claimant also retains at least 50% of the damages, if not more. Now, the budget obviously plays a very important role in this economic analysis. As funders, I think it's always very much appreciated if the law firm puts together a reasonable budget upfront. Usually in the process, we often work with the law firm to revise the budget, and we find ourselves actually revising it upwards rather than downwards. But it's always appreciated when the law firm can be forward thinking in its approach with the budget and anticipate as much of the cost as possible and be realistic about it. Because obviously, if a budget keeps changing, there is a danger that midway the case becomes not economically viable for either or both the funder and the claimant. In terms of what happens when the budget changes, right? I mean, there's a couple of ways of dealing with it. Oftentimes, actually, you might just have a funding agreement with a cap budget at the very outset. So, the funders will say, and Tom pointed this out earlier, this is particularly true when lawyers can't enter into contingency fee arrangements and share the risk. The funding agreement will simply say you cannot go over a certain amount, and if you do, you bear the cost of doing so. Now, alternatively, you can have funding arrangements where you have some sort of a cap budget, and you say, look, there are so few costs that the lawyers point out to say these may and may not occur. So we may agree on some sort of a 10 to 15% of a overshot on the budget. And that can be factored in upfront. You can agree upfront that you can overshoot the budget by this agreed percentage for no extra cost, so i.e. on the same terms. Or you can agree that if you do exceed the budget, then that's going to change the funder's commission by X percentage. Then you have sort of, over and above all this, your initial assumptions and considerations when you're putting together the budget dramatically change. And I think most funders are ex-litigators and will have sympathy for the fact that litigation is inherently unpredictable, and particularly where there are novel points of law involved or where there are unpredictable jurisdictions, things can change. And most funders, as Tom pointed out earlier, there's no sense in, nobody wants to see a case that's been well developed, torpedoed because of budget issues. So when presented with a request to increase the budget dramatically, then typically funders will look at, what's happened. Have the claimants and lawyers all acted reasonably? And is the increase necessary? Assuming that's, everyone's acted extremely reasonably, then it really comes down to the economics. And this will depend whether or not the funder agrees to the increased budget and on what terms. Whether it's going to lead to more commission for the funder or something else needs to give. sometimes, right, if what do you do if the funder cannot fund it? It's because the economics might simply not work, and then the law firm should also think about, and together with the claimant, about can the claimant put in more money, for example. Could you consider alternative sources of financing to supplement what you've already got? Could you perhaps take out a more traditional loan? Could you bring in a new funder perhaps and agree terms with everybody as to how priority and things like that will work? I mean, all this will sort of, it's at the end of the day, I think it's not an ideal situation, and to the extent it can be avoided, it should be avoided. But it does happen, and there are sort of that there will usually be a way around it.
Thank you. Okay, Alistair, coming back to you now. So we've heard the important factors the funders consider when evaluating the case for funding. And one important factor, I think we can all agree, is the quantum of damages. It's often relevant, of course, in preparing a case for funding, but also I imagine generally in your wider case strategy. So can you just describe the typical quantum issues or questions that you encounter, including in preparing your case for funding, and your approach to dealing with those issues, including perhaps using experts to help with those questions?
Thanks, Montek. I think probably the first thing to say is that actually you shouldn't see preparing for funding as an entirely separate stage from progressing the case. Tom made a very good point earlier that actually what you're doing is front-loading the analysis of the issues in the case. So you can see that preparing an application for funding is really beginning your analysis of the strengths and weaknesses of your case and where you should be putting your efforts. And so it's part of that early case development. That said, clearly it is going to be very important, as we've heard from Sindhu and Tom, that a fund gets comfortable both on the prospects of success and on the amount of recovery. And both of those things, especially in an infrastructure context, are likely to need assistance from experts. And if you take a very standard construction case, maybe you're arguing about delay, and that will give rise to issues, who is responsible for the delay? What is the schedule analysis? What is the financial consequence of that in terms of delay costs, prolongation costs? Those things, you can have a quantum expert to come and give an opinion on the cost of prolongation, but that's going to rely on some very detailed understanding of the delay, and that may itself require some expert input. It might even require some technical input in order that the schedule analyst can come up with a view on the cause of delay and whether it lay on the critical path. If you took a different example, maybe of an oil and gas concession or a mine, and you're trying to work out what the lost profits over 25 years of that would be, you might well need to understand the field plan for the oil field or the mine plan for the mine in order to understand how it was going to be mined and how much product was going to be taken out of the ground over what period in order to come up with a sensible value of how much profit has been foregone over a future period. And again, maybe if you thought of a project finance or a public-private partnership type context, maybe somebody's had a contract to build and run an airport for 25 years, and that goes south, and you're trying to work out what the lost profit there is. You might well need some very detailed industry analysis on patterns of air travel over a 25-year period in order to put some sense into what the dollar value of the loss is. So, short answer, how important are experts in preparing the case for a fund? Often critical, but they should be part of your case strategy anyway if you're getting into a very big infrastructure dispute at an early stage. The client is going to thank you for getting way into an infrastructure case before you actually start to think about whether an expert's going to back it.
I just have one quick follow-up. I'm going to replace the question I earlier had for you because you've already answered that in your opening remarks. But you mentioned, of course, the question of damages should be relevant regardless of the approach you might take, whether you fund it or not. Of course, in India, there are sort of differences on when experts get engaged generally in the process. But I guess my question for you is, do you see the involvement of perhaps experts being higher when you're going for a case for funding than your overall than otherwise, because you can often time it and progress the expert work over a longer period of time? Or do you think the involvement is as much, notwithstanding whether you're going for funding or not? So I just mean the early involvement of experts, more specific to that question.
I suppose particularly in the funding field, it's possible that there may be earlier involvement. In the quantum area, there may be earlier involvement of experts than in some other cases. Often in an unfunded case, you're looking first at the merits, and there may even be bifurcation of the case so that quantum is dealt with at a later phase. But quantum is always going to be important for a fund, and you heard Tom to say, they're looking for a 10-to-1 ratio of cost versus recovery. There's also going to be other metrics, one way or another. A fund is typically going to be paid either by taking a multiple of the sum that they've invested or by taking a percentage of the amount of recovery. Both of those are going to need some quantum advice from an expert. If you're taking a multiple of the sum you've invested, then you've got to know what you're likely to recover in order to make sure that you're on that 10-to-1 ratio. If you're going to take a percentage of the recovery, then you're going to need to know what the recovery is in order to make sure your percentage is going to give you a handsome return on top of your investment. So either way, that quantum analysis is going to be important at a very early stage, and possibly more likely to be looked at an early stage in funded cases than in unfunded cases.